Hello, welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and partner at the Edwards Wildman Palmer Law Firm in Boston. The IEEE is presenting this podcast in conjunction with a series of articles that I co-authored on legal issues relevant to people in the computer hardware, software, networking, and service businesses. These articles are appearing in the IEEE's Computer Magazine each month in 2012. This podcast is part 7 of our series. In the last podcast, we discussed open source software. In this podcast, we will discuss raising capital to start a company. Joining me today for this podcast is my colleague Richard Kimball. Richard is a seasoned corporate attorney. He has represented technology companies and investors in more than 200 venture capital financing transactions. He's a partner in the Boston office of Edwards Wildman Palmer and co-chair of the firm's technology practice group. Welcome, Richard.
Thank you, Brian.
Richard, there's a wide variety of sources of funding for an entrepreneur looking to start a business. Venture capitalists, angel investors, incubator programs are a few common examples. Venture capitalists are pretty well known. Can you describe how an entrepreneur would normally approach a VC and be prepared for what's expected in their initial meetings and discussions?
Sure. This may sound a little self-serving, but the best way to approach a venture capitalist is through a trusted source. As you might imagine, venture capitalists are inundated with business plans, executive summaries, and PowerPoints from people looking to raise capital. It can be very hard to get their attention unless you're introduced to them by someone they trust to have an understanding of the types of companies that they would typically invest in, such as attorneys, accountants, and others whom they work with and have a working relationship with. I'm often making introductions to venture capitalists. However, I'm very judicious about the companies I introduce. The actual meetings with venture capitalists can take various forms, and before a venture capital firm will make a decision to invest, the entrepreneurs will likely have multiple meetings. There may be 1 or 2 meetings with 1 or 2 or a limited number of investment professionals. These are folks who will become the advocates for the company. The initial meetings are apt to be rather informal. However, the entrepreneur should be quite prepared, as first impressions are very important, and there is not likely to be a second meeting if the first one does not go well. The entrepreneur should have a good understanding of the market and where their technology will fit in the market, who their competitors are, what their competitive advantage will be, whether they will have an important barrier to entry such as patents, or will they be highly dependent upon obtaining a first-mover advantage, such as many social network companies and applications. They should be candid about their technology risks and what management additions they will need to add to their team. They should not underestimate the amount of capital they will need. Many entrepreneurs try to cut their capital requirements too close to the bone in order to preserve as much equity as possible. Missing milestones and running out of cash is not an enviable position to be in, so they should be very realistic about the capital requirements. Things will not go perfectly, and the entrepreneur would be well advised to plan accordingly.
Let's assume that those meetings go well and the VC decides to invest. What happens next?
Ideally, you would want to be speaking to a number of VCs for a number of reasons. Depending upon the amount of capital that is required, the financing may be one that will require syndication. Many venture-backed companies are financed by more than one venture firm, even at the Series A stage. Also, it's not a perfect market. As in any non-public market valuation, the valuations can vary quite a bit. The best way to get a sense of what your opportunity is worth is to have term sheets from a number of interested investors. Now, this can be a little tricky. As you know, you don't want to overshop your opportunity, as you can lose momentum fast. It's kind of like the house that has been on the market for a while. People start to wonder why it hasn't sold. Let's say you've timed everything right, and then you have 2 or 3 term sheets to consider. And believe me, timing is important because each one of the term sheets is going to provide for a limited amount of time for the term sheet to be accepted before it expires. And once it is signed, it will have a lockup provision in which it will be binding. Unlike the terms for the venture capitalist, who will not be bound by the terms of the term sheet, the lockup provision will prevent the entrepreneurs from speaking with other potential investors until the term sheet expires, which is usually 30 to 60 days.
Start.
You'll want to make sure you've lined up experienced counsel to guide you through this process and to help you evaluate the various term sheets. The valuation is important, but there are many other complicated provisions that are included in a venture capital term sheet which an entrepreneur will want to make sure he or she understands. But it's not all just about the terms. A lot of it is about the fit of the venture firm and the founders. Investors will conduct their due diligence on the founders, but the founders should also conduct due diligence on the investors. Money is fungible, but VCs are not. Some of them know certain market spaces better than others and have deeper connections and access to potential partners and collaborators who can assist the company to grow. There is also a big difference between traditional venture capitalists and corporate venture capitalists. You may get a better valuation from a corporate VC, but you need to be careful not to sign up to obligations that will give them rights that may chill your ability to do deals with or be acquired by their competitors. That could really limit your upside. Corporate VCs can often be a great source as a potential customer with ready distribution channels, so I do not mean to disparage them. Sometimes the best structure might be to include a traditional VC and a corporate VC. The traditional VC is going to be a good countervailing force for protecting your exit and ensuring you do not limit your market opportunities.
Fast forward to the point where the new company is off and running. Is the VC still involved on the board of directors, for example? And if so, how much control does the VC typically exert? In other words, how much control should the entrepreneur be willing to relinquish?
Oh yes, you can count on the VC staying involved. A founder should look at venture capital investment as a partnership. Just like choosing partners, you want to choose your VCs well. They're going to have board seats. At the Series A level, you may have more founder directors than investor designated directors, but it more likely, particularly if it is a syndicated transaction, to be one of a balanced board, such as 2 VC designated directors, 2 founder designated directors, and an independent director mutually agreed to by the others. The financing documents will also give the investors a fair degree of control over things that the company can and cannot do. Board meetings will probably be held monthly, certainly at least quarterly, and the investor directors are going to want to be kept apprised of the company's progress. One shouldn't look at this as a bad thing, though. Once the venture capitalists have invested, assuming everyone has their eyes on the same prize, that is, a successful and hopefully lucrative exit, the right VCs can be a great resource in helping a company achieve that. At its core, that is precisely what their job is. They have much more experience crafting successful exits than most entrepreneurs. Of course, they may have different views from time to time on just what might be the best way to get there.
How long does a VC typically stay involved with the company?
The typical VCs, or at least the good ones, will stay involved until the end, which is the exit. If the exit is an IPO, some VC directors will stay on the board after the IPO. Their contractual right to stay on the board, however, will expire at the time of the IPO. However, the underwriters will likely want to keep the board pretty much intact through the IPO and for some time after that. They may want to see a few changes, but certainly not wholesale changes. Some VCs will stay on boards of public companies for an extensive period of time, and they can be valued members of the board. However, many will cycle off after a year or two.
What about additional funds from other sources, angel investors or family and friends, for example? Can an entrepreneur ask for and get funding from a variety of sources for the one company? And how is that managed?
Sure, an entrepreneur can get funds from multiple sources. However, it is unusual to get funding from VCs and these other multiple sources at the same time. Founders will often seek capital from angels and friends and family as well before seeking venture capital, as they may be too early for venture capital and need to prove their concept. That having been said, I am seeing more and more VC firms putting small amounts of capital into angel rounds alongside the angels. These are not typically VC-led rounds, and they do not have the same level of terms as you would see in a typical VC round. It's more like a VC throwing a chip on the table to show some interest that it may be willing to fund the company down the road. The sums they invest in these types of transactions do not justify the general partner's time involvement as a director of the company, nor the amount of due diligence and documentation that would be required in a VC-led financing. Friends and family can be a good source of early-stage capital. However, entrepreneurs need to be careful about compliance with federal and state securities laws. While securities can typically be sold to a limited number of unaccredited investors, there's often a prescribed level of disclosure that is required when selling to these folks, and it can be costly and difficult to provide the required disclosures. Contrary to popular belief, there is no securities law exemption for friends and family. That having been said, the new Jobs Act should make it easier to raise capital from friends and family. The regulations, however, are unlikely to be implemented for a number of months and possibly not before the end of the year. However, folks should keep an eye on that, as it will legitimize crowdfunding. That having been said, entrepreneurs should always be thinking about the next step. And if the next step contemplated is venture capital, it's pretty unlikely that VCs will want to invest in a company that has a lot of small investors. You raised another important question, and that is, if a founder does raise capital from multiple sources, such as angels and friends and family, how is that process handled? Ideally, you want to have all of your investors be party to the same agreement, such as a stockholders agreement. Having all of the rights and obligations of your investors in one document, which they are all parties to, makes it less of a challenge later when you need to change some of those rights and obligations, which is almost inevitable, particularly if you will need to raise additional capital. A well-crafted stockholders agreement will allow amendment with something less than unanimous approval. You do not want to be in the position where you need to get a consent of a bunch of small investors in order to move forward on your next financing. That could be the kiss of death.
While recognizing that every deal is different, each having its own set of facts, what are some typical danger signals that an entrepreneur should recognize during the funding process that could suggest that the deal isn't right? Start.
Misaligned expectations and personality clashes. You really want to make sure you and your investors are on the same page and rowing in the same direction. That does not mean that you do not take investment from an investor just because the investor has a different view than you. It means you should listen to that investor and discuss your differences so that both of you get a much better perception of what the other is thinking. It may be that what the investor is suggesting makes a lot of sense, so it is important to have an open mind and open ears. But in the end, if each of you have two very different notions about the vision of the company and how best to achieve success and how long it will take and how much capital will be required, it is probably best to part ways. You also want to be comfortable working with your investors. It's not a popularity contest, but it will be a partnership, and you will be living with them for 3 to 7 years. So it's important to keep that in mind. The relationship doesn't end when the check is cut. That's just the beginning.
Thanks, Richard, for your views on this. We hope that you found this podcast helpful in understanding some issues involving raising capital. Stay tuned for our next installment in Computer Magazine. Until next time, this is Brian Gaff
And Richard Kimball.
Feel free to contact us via email at bgaff@edwardswildman.com
or at rkimball@edwardswildman.com.
Thank you.